Good day, everyone, and welcome to today's panel discussion titled Ripped from the Headlines, Unforeseen HIPAA Disasters and How to Avoid Them. I'm happy to be hosting today here from Etna Interactive and excited to introduce you to our panel of experts. My name is Ryan Miller. I'm the CEO of Etna Interactive and functioning as your moderator today. Now, I'd like to introduce first Bob Aicher. Robert Aicher has been General Counsel to the American Society of Aesthetic Plastic Surgery since 1998. Previously, he worked as General Counsel for ASAPS, the California Society of Plastic Surgeons, and the Doctors Company. Bob's a past president of Sonoma Valley Hospital and the Sonoma Valley Community Health Center. He resides in Pasadena, California, with his wife, who you may know, Jill Hunting. I'm also excited to introduce next Mike Sacopulos. He's the CEO of Medical Risk Institute, providing proactive counsel to the healthcare community to identify and help remove risk. He's written for the Wall Street Journal, Forbes, and Bloomberg, and many of you may have seen him as a frequent national speaker. He attended Harvard College, the London School of Economics, and Indiana University, Purdue University School of Law. And last in our lineup today is Jeff Segal. Dr. Segal is a board-certified neurosurgeon who trained at Baylor College of Medicine. Dr. Segal also graduated from Concord Law School with the highest of honors. Dr. Segal launched Medical Justice back in 2002. For those that aren't familiar with it, Medical Justice is a physician-based organization focused on keeping doctors from being sued for frivolous reasons. Dr. Segal also founded eMerit to help doctors protect and preserve their reputations, particularly online. Gentlemen, it's my pleasure to welcome all of you, and my thanks to you for participating and volunteering your time for our audience here today. For everybody that is listening, the session is being recorded, and as I mentioned just before we began the session, those who are participating in the live event will have the opportunity to ask questions using the question panel on the right-hand side of your screen. Now, to kick things off, the way that we will be approaching today's webinar is a series of 5 vignettes. We'll spend about an hour together, and let's lead off with this one, a story that came out of Modern Healthcare about a fairly massive settlement on behalf of Children's Medical Center in reaction to 2 specific HIPAA violations. Now, one was a loss, one was a theft, the loss of an unencrypted BlackBerry, effectively a smartphone, and the theft, as we understand, as was alleged in the second incident, of a laptop, both of which containing patient information, and specifically what is called PHI, or protected health information. And as a result, the hospital ended up paying a $3.2 million settlement to the federal government. So to lead things off, we're going to start the discussion today with HIPAA and office hardware. And as I've seen over and over again, I'll be at a meeting and a doctor will bust out his smartphone, and on that phone there we see before and after images of patients. We know that staff members are engaging in text communications or email communications on their personal devices. So if we can, Bob, I'll ask you to lead us off. What in fact are the risks for practices that are storing PHI, again, that's that protected healthcare information, or patient photos on their smartphones or their laptops?
First of all, who owns that phone? And he said, Kaiser does. And I said, what happens if you lose it? And he said, well, we go ahead and notify the IT people, and they have a kill switch to go ahead and kill it. But clearly the risk is still there that if you have PHI on your phones because of its convenience, and then you misplace it or something, then it can fall into the wrong hands. So I think the risk is very real. Even taking pictures that he uses now with software, which instantly go into the electronic medical records.
Well, then let's kind of build on that, because the thing that we see very often is, I think there's this presumption that, well, I have a password protection on my phone. I've got to enter in that 6-digit code, or my laptop screen locks. And Jeff, if I can move on to you, reasonably speaking, what should practices be doing if they're making the choice that, hey, I'm gonna keep this PHI, and for those that aren't familiar with the term, it's that protected health information. I'm gonna keep PHI on this portable hardware. Is screen locking enough? Is that reasonable measure?
So it's interesting is that when I first saw the vignette that talked about a lost BlackBerry, I had to do some research to better understand what is a BlackBerry. Actually, I had a BlackBerry and I lost it one time for about 4 hours. So I do feel their pain. But the short answer is that there are lots of things to worry about as it relates to HIPAA and privacy, et cetera. But the thing that gets most entities into trouble is losing a portable device, losing a smartphone, losing a laptop, losing a tablet. And so what does HIPAA require? It just requires that you do what is reasonable to secure the information that is protected health information that might be on there. So simplest thing you can do, make sure every device is encrypted at rest, meaning that the core device is encrypted. And most Apple iPhones come out of the box encrypted. The Android phones, most of the new systems come with encryption clicked on. For some of the older ones, you probably have to click a toggle, but I would just say, just make sure it's on. Once you make sure it's on, then that's actually a very good thing. The next step is, well, what about the screen lock? What about the password to open and close the screen? Nice to have, but valueless as it relates to encryption. All it really does is suggest you've got to go through an extra tiny step to open the screen, but that is not encryption, and that is not considered a reasonable way to secure the phone. I would say do it. You should definitely do it, but it's not considered enough. You really need to make sure the phone and the laptop itself is encrypted. What about encrypting your laptop? Some pieces of software come native with encryption, meaning some operating systems are native with encryption. Others, you need to add third-party software to do it. It's really simple to do and set up. I would just say do it and forget about it. You just need to make it happen. Number two, as Bob alluded to, you need the ability to wipe the phone. So everybody's bringing their own device into their office today. They're using it for personal reasons. They're using it for business. That's, if you want to attract and hire people, you have to accommodate that. So you want to have a bring your own device policy in the office that everybody signs off on. Many of those are available. I think Mike Sacopulos has some available that I'm guessing will be able or happy to share. You probably have to catch him after the presentation. But a bring your own device agreement basically states that if you are using your phone for business purposes and the phone is lost, you need to agree to a kill switch, a way to actually track the device and wipe the device. So that's the trade-off. If you want to use your personal device, you need to, you can definitely get the benefit out of it, but you also need to accept the risk that if you lose it, somebody, namely whoever controls the office, will need to wipe it. And then finally, where does the information go? Some of the information is stored on the phone, but pictures, for example, are often stored in the cloud. And so if it's stored in the cloud, you probably need to make sure that it's stored securely, which means that the place where it's being secured, you need to have a business associate agreement, a HIPAA business associate agreement. So I know that if you've got a Google business account, you've got by default, a downloadable HIPAA business associate agreement. There are other entities where if you've got business accounts, they do provide this, but for personal accounts, they don't necessarily have that level of security. I mean, I would say they probably are secure, but they don't go the extra mile to delivering this beautiful piece of paper that you would need and want if the HIPAA police come and to Children's Hospital and say, we're going to fine you $3.2 million unless you let us know precisely what you did to prevent these problems. So that's a whirlwind tour of some of the things to think about, but there's certainly more.
Yeah, and I think a couple things that jump out there. Most PC laptops don't come encrypted out of the box. So for those on the call, if you're interested in exploring that, talk with your IT team. They can add encryption for you. I think your comment about photos taken on a phone, by default today, for the most part, these are going to end up somewhere in the cloud. And you need to understand that a lot of the wiping functions that are available, they might wipe a phone, but they don't necessarily wipe the copies of images that may have come off of an employee phone out into the cloud. So that does create long-term risk, knowing that that PHI, that those photos are out there should you separate from a member of the team. Thanks, Jeff. Let's build past there. And Michael, if you don't mind, let's go just a little bit deeper without getting too much fixated on what IT professionals might advise, given that everybody here today is a legal professional. What do you advise from a policy standpoint and perhaps even staff training as it relates to hardware security? What should be a part of either the catch-up or the onboarding with staff?
So I think Jeff did a great job talking about mobile device or bring your own device policies, and every organization that is allowing people to have any kind of protected health information on mobile devices needs to have a policy. But I'd like to focus more on the training, because frankly I see that as an area that does not get enough attention. So much when we're talking about security systems, people think of hardware, and it's really not your Citrix firewall that's going to get you the problem. It's your employee. Studies are showing 90+% of hacking and ransomware are the result of an employee clicking on something that they shouldn't, a phishing email, social engineering. And so this is where I think effort needs to be spent training staff to understand these kinds of hazards, or actually going on to free Wi-Fi areas and logging into your systems where someone could track and pick up passwords. These are kind of basic cyber hygiene that unfortunately does not get trained. People don't receive enough training on it, and where we have lots of problems. Even down to passwords. There was a recent study, and maybe some of your listeners have seen this. 2 most common passwords, and I ask without fail audiences every time I speak, what are they? And without fail, multiple people cry out 1, 2, 3, 4 or password. You know what? They're right. Those are the 2 most common passwords in the United States. And not only that, they've been the 2 most common passwords each and every year since 2010. So with that kind of cybersecurity, why should we be surprised that people have problems, right? This is the kind of training that we need. People need to have secure passwords. We need to have policies on this to avoid so many kind of problems.
So we've got our first audience question coming in by way of the question control panel, and anyone can feel free to jump on this. Glenn was asking about the risk and how it may differ if the photo is taken by the staff member on the phone, or if the photo is received, for example, by way of text, being sent directly from the patient. Is there some kind of forfeit of HIPAA rights if the patient pushes an image to a member of the staff by way of text?
Yes,
this is Jeff. Go ahead, Mike. Sorry, keep going.
No worries. So the Office of Civil Rights, who oversees this, oversees HIPAA enforcement at the federal level, says that if a patient initiates a communication, whether it's the sending of a photograph, an email, a text, in an unencrypted or non-secure way, they are certainly allowed to do that, and you may respond to them in a similar fashion. It is assumed that the patient knows that they are doing this in an unencrypted fashion, and you may respond accordingly. So there is, to some degree, yes, a waiver. But remember, patients can do anything they want with their own information. It's your handling of their information that these laws cover.
Yeah, let me follow up with that. So once the photo shipped from the patient is on your phone, it is presumed that it's going to be treated in a private manner, meaning that you're going to secure it. Just imagine for a moment that the patient sent a text saying that they're HIV and they're taking medications for bipolar disorder. While the patient has chosen to use a unsecure channel to communicate that, once it goes in, it becomes part of the record, and text messages should become part of the record. You have a duty to secure the information and not be cavalier in terms of how it potentially may be disclosed.
Excellent. So thanks, gentlemen, and thanks, Glenn. Let's move on to our next case here. I pulled this headline directly off TMZ, perhaps the most reputed source of news out there. But this story does appear to be real, and allegedly there's a Beverly Hills plastic surgeon where I believe, as the story is told, a disgruntled former employee left with files and photos for approximately 15,000 patients, including some celebrity patients. So let's talk about HIPAA and the inside job. And in this case, it seems like maybe there was some bad intent. And Jeff, if we can lead with you, is this a HIPAA case at all, assuming that this is purely a cosmetic practice, or are there other legal issues that are more likely to prevail in this circumstance?
All right, so I'm going to give a lawyerly answer, and the answer is, well, it depends. And here's why it depends. So let's just talk about HIPAA in general. So HIPAA is a very formal federal law the federal government has the cause of action, meaning that if you have a HIPAA violation, the Office of Civil Rights and the Department of Health and Human Services can take an action against you. So the patient's not really suing you directly with HIPAA, but you still can run into a lot of regulatory problems, in particular a giant fine. And so HIPAA is codified in statute and basically is focused on transmission of information over electronic lines, most often related to filing insurance claims. And so I think the subtext of the question is that to the extent that it's a cash-only practice and you don't take insurance and no insurance claims are ever filed, does this come under HIPAA? And I would probably take a much broader view of this, because HIPAA isn't the only way you're going to get burned. And if we just think about the bucket of HIPAA, you can and will get burned. So here's what I mean by that. If protected health information or confidential information is disclosed inappropriately in a way that the patient had expected you keep this information under wraps, there are a host of remedies available to the patient under state law. And under state law, they can sue you directly for money damages. And in doing so, many entities, many courts, and if attorney generals come after you, have said they look to HIPAA to guidance, to give them ideas as to what is appropriate and what is not appropriate under HIPAA. So even though formally a cash-only practice that takes zero insurance may not, in theory, come under HIPAA, from a practical standpoint, you're still kind of following HIPAA if the end result is that you don't want to be sued by the patient for invasion, or I guess invasion of privacy would be, public release of private facts. There are a host of different legal theories on which they can recover money. So the goal, of course, is to stay safe. And I think HIPAA does apply, even if it doesn't apply directly and specifically.
So, before we move on, I might invite either Bob or Mike to chime in on this one, because this is a fundamental point that we hear come up quite often. And I think, Jeff, the answer I heard you just give was this, that if you are a purely cash pay practice, as it relates to the letter of the law, HIPAA doesn't technically apply to you, but the measures of HIPAA may find their way into a case they may influence ultimately how a case is prosecuted if you reveal sensitive private information about your patients.
I think what I'm saying is that the federal government may not be interested in you as a cash-only practice. And by the way, the first thing you would be doing is that you'd have to be defending yourself. So if you're explaining, you're already wasting time. So let's say someone files a complaint, goes to the Office of Civil Rights. It's a federal case. They come in and say, hey, there was some disclosure of protected health information. And your first argument is, hey, HIPAA doesn't apply to me. You can make the argument, but then this is going to let's assume you win and you're successful. Then you're going to run into state-based entities like the Attorney General potentially taking an interest in this case. And finally, the patient, who's most likely to be the one pissed off about this, is just going to pick up the phone, call a lawyer, and then sue you privately, basically saying that even though HIPAA doesn't apply, the standards of HIPAA, although not codified directly in state law, are looked to help judge whether you did something bad or not.
Point well made. So I think as we then move past that, Michael, I'll ask you to jump in. We'll talk about liability for employees at greater depth a little bit later as we look at some other cases. But in the context of this case, what liability exists for if what is alleged in this case is true, that a disgruntled employee took records, and I think if I've read more of the story correctly, there may have been some intent to kind of blackmail or hold hostage the practice to get this data back. What is this employee looking at in terms of liability?
A lot of different problems, actually. And as I understand the facts, the employee also was taking photographs of anesthetized patients. So there's a good bit of information that was taken, which leads to lots of different areas of potential liability. Assuming that the practice would come within the purview of HIPAA, employees can receive up to 10 years as a federal crime for violations. It's tiered, so depending upon the level of culpability, right? And this would seem to be clearly malicious and exploitive, and so potentially qualify for a 10-year federal sentence. But certainly there are plenty of laws that would govern, and Bob is based in California and may well know criminal codes there. But since this practice is based in California, but certainly taking information, and that means the patient's charts, even if it's a copy electronically, you're taking property that is not yours, and so there is certainly a theft element here as well that could be prosecuted under state law. And so in addition to monetary fines that could come, there are both federal and state criminal charges that this employee may be subjected to.
So it's not just creepy, it's criminal potentially in this case.
Exactly.
So Bob, if we can move on then a little bit, it occurs to me that there probably, in this case, there probably were some warning signs, but either way, the material in this case is the fact that this is a former employee that was involved. What reasonable protections do practices need to take when they're separating from employees today who've had access to sensitive records in the course of their work? As we discussed in the last vignette, looking at hardware, they may or may not have PHI on their hardware. Does the society have a recommended protocol, or have you seen something out there that's a guidance for practices in separating in a HIPAA charged environment?
Sure. The society does not have a position on this, because since we represent aesthetic members, we try to stay away from HIPAA practices. But frankly, everybody's practice is almost all practices are blended. Before I get to what to do with those separated employees who can sync you, I wanted to go ahead and add to what Jeff was saying about whether HIPAA is going to apply. It is true that HIPAA, for the most part, only applies to the electronic transmission of protected health information, to and from insurance companies or third parties who help with, getting payment and such. And the proof of that is if you go to the Office of Civil Rights website, they're really proud of the statistics that they've been keeping since April of 2003 on their enforcement actions. But when you look at it, you realize that up through June 30th this year, they proudly announced that they've received almost 159,000 HIPAA complaints. Wow. But of those, 62% were dismissed for lack of jurisdiction. It was either the entity of the transaction wasn't covered by HIPAA at all. Another 7%, there was no violation. Another 14%, they resolved through what they call early intervention by providing technical assistance, which means that of these thousands of HIPAA complaints, 83% were resolved without an investigation whatsoever. And of the remaining 25,000 investigations, only 0.2% actually required enforcement actions. So, the good news then is that you've got an 83% chance that nothing bad's going to happen to you as a result of a HIPAA. And that's actually a HIPAA complaint, not just a threat, but actually a complaint being lodged. So that does go to the issue of how often these things apply. HIPAA oftentimes doesn't apply. Nevertheless, as Jeff also said, privacy always applies. And to Mike's question, although I'm in California, I don't hang with criminals, so I can't tell you what the criminal code is off the top for stealing this stuff, but it's still going to be there. So what can you do? I have seen employees leave, and there is a way that you can go ahead and kind of deal with it. Usually it arises in the context of what I like to colloquially refer to as thieving estheticians. They're employees who jump ship to another surgeon's practice. And of course, one of the most valuable things they can bring with them is the patient list. So automatically now they're stealing. It's rare that I've seen that they actually take only a name of a patient without anything attached. Of course, they go ahead and take everything attached because that's what the new plastic surgeon wants to hire them for. So a way around that is that if you know that the employee is leaving, then they may not have a severance package, but what you can offer is a little modest severance pay And then by doing that, now you can couple it with a release and an acknowledgement as that they're not taking any PHI to kind of put it on the table. You can also, as part of that, remind employees in their settlement agreement that customer lists forever, long before there was PHI and long before there was the internet, customer lists were always trade secrets. And so you can identify in there that the patient lists are trade secrets and that the employee is not going to take any of that with them. If it happens, of course, that your esthetician has left and has taken this, and you find out, as I've seen members do, from a disgruntled patient receives a solicitation from the new location, you contact the new plastic surgeon. You remind them that what has happened here is a theft of PHI and or a theft of trade secrets, and you just remind that plastic surgeon that if you see one more hint of any advertising based on this information, then you're going to lodge a complaint with the medical board for unprofessional conduct. And sure enough, that works every time.
So it sounds like it's prudent both to, as you're bringing people on board, as a part of their orientation, to make sure they understand that, not just what the requirements under HIPAA are, but that your patient lists and their data are trade secrets. And it's prudent to remind them as well at the moment of parting that there's liability should they try to take any of that information with them.
That's right. But I prefer the carrot as opposed to the stick. So if you can, bring yourself to go ahead and offer a little bit of money in exchange for putting that in writing that they sign, then you know that your message will have been received in a better spirit than just don't even think about stealing anything from my practice, or I'll go ahead and report you to the authorities.
Excellent, Bob. Thanks. So just a quick reminder for all that are on the call in our live session right now, the GoToWebinar control panel that should be on the right-hand side of your screen offers the opportunity for you to drop questions in as we're talking. I'll do my best to work those in during moderation. Those that we can address, we'll try to get to at the end of the session. But it's time now to move to our third vignette. This particular one in the New York Post, of all places, surgeons posted pics of my boob job after I refused, lawsuit. So what I think the patient is alleging in this particular case is that they had failed. They did not provide consent for their before and after photos to be posted. It sounds as though the practice thought, oh, no big deal. We're just not going to show the patient's face, but we'll post their body and breast images anyway. But this particular patient had identifiable freckle patterns. So let's talk about HIPAA and consent. Michael, maybe if you can lead us off, like really what's going on with this case? What is the case?
So two things, a little bit deeper into the facts. Here the patient had signed a consent, but limited the authority to use her before and after photographs to only medical education. Specifically would not sign for any kind of marketing or advertisement use of her photographs, but yet they were used in that way, put on a website before and after to promote the practice's ability to perform breast augmentation. So I think we have, your question is what's the case about, and in my mind we have really two factors. One is a system failure because there was a consent used. Someone recognized the fact that we need to have a patient consent to use the photographs, but then failed to look at the actual consent that the patient gave, which was not for how these photographs were used. Secondly, I think that there is, maybe in this case, but certainly in many similar to it, a failure to understand the full scope of protected health information. Unfortunately, there's a thought that if a patient's name or their face, a photograph of their face, is not included, then somehow we're okay. And that has led to any number of different privacy claims and HIPAA violations coming about, just thinking, well, who's ever going to know, right? Unfortunately, people do know, and there have been some other spectacular examples of that through social media and websites. So I think, in my mind, we really have two problems. One, a base failure to fully understand the scope of protected health information, and then we had a system failure within the practice. Someone had the patient signed a form, but then didn't bother to check what form was signed prior to posting. And by the way, these photographs apparently were on the internet for more than a year before the patient found out, only adding to her general anxiety and lawsuit.
So, well then, Bob, let's move on from there and just let's kind of go. Let's think about something broader than just the patient before and after photo, because as you just mentioned, Michael, social media is a concern, which is going to involve both still images as well as video content. Like in every instance that a patient image is present in something that's associated with the practice, is consent always necessary, Bob? Like, let's just use the example of something that is the practice is doing a health fair and they have a 10 by 10 booth and they take a selfie with somebody who's walking by and they use that, or they host an evening of beauty and there's no implication that the person is treating, they're just there socially. Is the consent always necessary?
No, the consent is going to be necessary, however, anytime that you have, patient protected health information coupled with the photograph. So a photo by itself that doesn't have any health information to it, well, it'd be a stretch to argue that just taking a picture with a plastic surgeon is somehow protected health information. I mean, even the photograph itself, HIPAA only protects full face photographs. So I can see why this particular patient, she's suing in state court, obviously, because she has no private right of action under federal court. And even if she did, we're not talking about a full face photograph. So she wouldn't have a right of action under HIPAA. But when you're getting consents, I think it's really going to the issue that Michael discussed, which is patient expectations. Yeah. That's what you're really trying to manage here. And so if you're using old releases, which say for educational and scientific purposes, oh, give me a break. How old are you? That's not going to be enough. If it shows up on the internet, releases have to be expanded to at least mention electronic distribution, publication, preferably the internet. So are consent forms always necessary? Well, it does depend upon the context, but simply taking a selfie or something, no. Photos during non-medical practice events, no. There has to be something medical about a photograph.
So you mentioned the dated consents. If I remember correctly, Jeff, you've generously offered in the past a templated form of a contemporary consent. Is that still something that you offer, that you make available?
Yes, it is. So yeah, thanks for making that available. We make it available, you bet.
And I might see if we can link that from the blog post that will follow, where this recording will be offered for posterity and for people who want to gain access to that. But let's just kind of wrap up this idea of consent. And I'm just wondering, are there, in your role, you guys deal with this stuff so often. Is there something that you think that practices need to just understand about consent that is really often overlooked?
Yeah, so consent is more than a document. It's managing expectations and it's communication. Most of the time, when there's a conflict, it's due to a breakdown of communication, and as Bob pointed out, managing expectations. So to the extent you've got good communication of managed expectations, the document should support that. And so in this particular case, it came down to how the photographs would be used. And the patient explicitly said, please do not use it on the internet. They were used on the internet, so you can well imagine the patient is unhappy. And even if the document suggested that it could be used on the internet, there still was a clear breakdown in communication. So I start by thinking about communication, manage the communication process, and the document should mirror what was addressed during communication. But so what do practices need to know about consent? What are some things that I didn't know about HIPAA releases, for example? I'd assumed that the word HIPAA, consent and authorization, in the world of HIPAA meant the same thing, and I was slapped around by the people at Health and Human Services, basically saying, no, if you're looking for a definition, we're really more interested in authorization than consent. And I don't want to get into a detail over the semantics of this, but HIPAA is focused on authorization, so they don't even really care about consent. It's authorization. But for what practices need to know, a HIPAA compliant authorization has a number of elements in it, one of which is describing the scope of how the information can be disclosed. So yes, disclosing it, for educational purposes would be one thing. Putting it out on the internet would be another. Using it in marketing material would be yet another subset. A bunch of different boxes. Just check every box that you want to use. In that, it also has a clear statement, which is that once protected health information is disclosed, the toothpaste is out of the tube. And I would probably use different language than that. But it may very well be that you can't undisclose it, even though the patient has a right to request that it not be disclosed any further, and that needs to be one of the elements in there. The ability to make this public information private again may be impossible. So, for example, if you stick pictures out on the internet, it may very well be cached in Google Land, or any other site that keeps images, that scrapes images off of there, and even if the patient requests that it be taken down, it may be accessible. That said, though, if the patient says, please take it down, don't hesitate. Just do it as quickly as they've asked you to take it down.
Did that bit of learning, Jeff, is that going to encourage you to alter your position on releases and move toward consent forms and move towards authorization, or is that just trivia?
It's trivia. Consent and authorization to the average patient, or to 99.999% of people, they're equivalent and synonymous. But, if you look at the statute, the word is authorization, and I think authorization is the correct word.
Excellent. Well, in the interest of time, let's keep moving then, and let's talk about two stories that had some overlap. There's some similarities here. In one, both cases involved the firing of a nurse. In one, a nurse who was perhaps insensitive and a little imprudent made a comment on Facebook following the passing of a patient who'd been treated in her hospital. And another, California nurse was fired for accessing records to which she had no business looking at. In both cases, commonality to me seemed was that they're simply, imprudent or ill-advised actions that resulted in an employee losing their job. And so, Bob, if I can come back to you to kind of lead this section off, while each state has its own human resources laws, how do employee off-hours activity? I think in both cases, or in the first case at least, the employee made the post when she was not on the clock. How does that intersect with HIPAA?
It's just not going to matter whether the employee has punched the clock or not. If the employee is in possession of private information, then they have to treat it that way at all times. And that takes us back to my initial comment when we first started this webinar, was that with the rise of social media, boundaries seem to be relaxing so much that everybody doesn't seem to have a problem posting anything about anybody on social media. It's really horrendous what's out there. It probably doesn't get prosecuted nearly as much as it ought to be, but doctors are great targets. So if something goes wrong, then of course they're going to get prosecuted. I would suggest that when it comes to trying to remind employees of their obligations, both on and off the job, that you try something different, namely before you hire that person, as well as periodically during, just look at your employees' social media accounts and make it a requirement that they friend you so that you can actually see whether that employee has boundaries or not. And if they don't have boundaries, if you can see that, then sit them down. Either don't hire them or sit them down and explain before something goes wrong. You can't be doing this, because if you're willing to do this in this context, you will likely go ahead and violate our patients' privacy rights as well. You just have to stop it and try to try to overcome society's acceptance that it's okay just to put it all out there.
You know, and I think this may be an HR question more than anything else, but I'm aware of at least one case among our clients where a front office worker had sort of adopted the standard practice as she was building relationships with patients who were waiting in the waiting room of friending them on Facebook. And then on one fateful afternoon, she'd had a bad day. She badmouthed a patient on Facebook and had forgotten that she had actually friended that same patient on a previous visit, and that person lost their job. Is there any policy that you're aware of that can be set, and I think it probably is state dependent, to discourage that, or is all the best that you can do to remind people that your personal choices are your own, and if you make connections with our patients and if bad things happen, it's probably going to cost you your job?
I would take the latter. I just don't think that you can dream up every possible scenario when employees are going to make just astonishing errors. One member called me to say that his nurse was planning her bridal shower. And so she sent out a blast email to everybody making the announcement. And yet she didn't use her own personal email listserv. She used the office. And not only that, she put everybody's email, instead of in the BCC line, she put it in the CC line, so that every single person who received the announcement about her bridal shower now knew the name and address, email address of every other patient of the practice. Now, as it happened, the doctor called me and we talked about it. He said that he had received a couple of phone calls from patients who were just a little irritated. On the other hand, he also received several phone calls from patients who said, it's been too long, and they scheduled for another appointment. Okay.
So
he got nobody complained, but that could have been a major disaster. So how can an office policy anticipate every amazingly unconscious thing that employees are going to do? I don't think you can put that in a policy other than thou shalt respect thy patient's privacy at all times or else.
It's interesting. That's why contracts are now 45 pages long. They are just the accumulation of things that people had not thought about in the past but actually happened, and that's why the contracts keep getting longer and longer.
Well, so Jeff, while I've got you, let's keep going with this case. So there's the second one I mentioned of the employee who was going through records that weren't patients that they were caring for. Just kind of sounded a bit like snooping. Is it really a HIPAA risk for an employee to be curious and to go back through old files, or what's that all about?
Yeah, it for someone who does not have a need to know, they have no business looking in a particular record. And this is not an isolated case. There are many times that people who just work in a particular institution have wanted to check in on perhaps a celebrity, or they wanted to check in on an ex-girlfriend or boyfriend, and the electronic record tagged it and it was audited. And once it was discovered, the entity had little choice but to fire them, because it really is inexcusable for people who have no authorization and no need to know to jump in and start snooping around. So yeah, it's no different than thinking about this as privileges as it relates to information technology. If you've got more than 2 people or 3 people in your practice, which I'm sure many people do, not everybody has admin privileges. You really want, some people in the need to know, or that have everything privileges, but then others just have the appropriate amount of privileges to do their job. So yeah, I mean, it's unfortunate that this cost the employee her job, but not surprised.
Well, and thanks for that. And Michael and for everybody on the call, I think we're clear that we're gonna go a little long today, but this is a great topic, so I want to keep us going. My understanding is that for practices that are in fact covered entities that are covered by HIPAA, that training for employees is mandatory. What training, especially as we look at this issue, what training needs to be in place to guide employees? If you can, just kind of a tight answer in that area.
Well, let's talk about in the social media framework, because Bob's absolutely right that people seem to be somewhat, when it comes to social media, just become disinhibited and do all kinds of things. And so to the extent of what kind of training or policy do you need to have, most institutions now have, and you can find them online with Mayo Clinic or Cleveland Clinic. Check and see what their social media policy is. Sometimes that's instructive, and it's actually more on the HR standpoint that they're doing this, because it allows for dismissal of employees for really inappropriate things on social media in a justified way. And we've had some rulings out of Ohio citing social media policies as the basis for proper termination of employees. So certainly that's something to consider. I think that I have seen cases where we've had problems where people say, I work in a physician's office, or more specifically, I work for Dr. So-and-so, and then proceed to give medical advice. And I think this is something that you want to caution employees not to do. They're essentially trying to use their position at your practice to legitimate the medical advice that they're giving, and oftentimes nothing good comes of that. So some specific type of training as to social media risks, and they're out there, right? We've just named a number of different cases where people have had problems, practices have had problems. As to the unauthorized looking at medical records, whether it is for innocent reasons, and so oftentimes that happens, especially in small practices or in smaller communities where everyone seems to know someone and is worried about their next door neighbor's cousin. Again, that just it needs to be reinforced that you don't have to have ill intent. The law applies, and people have privacy as to their records, regardless of your intent as to why you're looking at their records. And so a little bit of instruction there, I think, goes a long way.
Excellent, Mike. Well, thank you. So, let's talk about this, and I think this is probably going to be the highlight of the webinar. As we close and we touch on some with something I think that's near and dear to everybody's heart who is participating today, which is the relationship between HIPAA and responding to reviews. This story out of the San Antonio Express News of a doctor who allegedly was retaliating by posting nearly naked photos of an unhappy patient. After she commented, she shared a negative review of that doctor online. The case, as I understand, is allegedly doctor retaliating in reaction to that negative review. So, we'll work our way back around, and for each of you, the bottom line is, I think I've heard a lot of confusing or misinformation about what a doctor can and cannot do when responding to reviews. And so maybe let's start off, Bob, with you, and just what is the advice that you give when this question comes up?
It's always the same advice: don't feed the animals. And most of the time, everybody I say that to gets it, and they just kind of live with it. Because if you have a negative review, you've got an unhappy patient, okay. But what they're oftentimes doing is they're kind of looking for a relationship. And so if you start responding, then you don't know whether you can actually mollify that person, or if you're going to aggravate the situation. If you want to find out after the online review is there, call the person, call the patient directly, and see what's going on. If you feel absolutely compelled to say something online, then you can, but you can only respond in kind. You can't reveal any information that wasn't already revealed by the patient. You're going to want to make sure you respond in the same forum. But even then, don't be surprised if they come back at you and rip you to shreds. When our members do want to put something online, though, I remind them you aren't really talking to this particular patient. Who you're really talking to is all your potential patients who are looking at what your comments are to see whether you are the professional that they want to come see. So I always recommend something pretty innocuous. We're always concerned anytime our patients don't experience, optimal results. I invite you to contact my office, schedule an appointment, and let's see how close we can come to your goals. Something like that. What this particular doctor did there was just, well,
nuts. It was nuts.
It was just fill in the blank, and everything bad that happens to him from doing that, he had it coming.
Yeah, so obviously retaliation would not be recommended. Mike, what would you add? What would you build on that? And then Jeff, we'll have you close us out. And I've got a couple questions from the audience here.
So I think Bob's answer was right on point. You can be very careful when dealing with these people, and your audience is clearly not the individual that you're responding to. Generally, I try to tell my clients that you don't want to ignore this, but you want to put some kind of a response that doesn't get to the merits of what they're saying. Right? Sorry that you're unhappy. Please contact us. Right? And don't go into the into the facts, but yet you want to appear caring and responsive to patient complaints. So there are also some really good studies out there that show a negative review here and there add to greater legitimacy for all the positives, and it doesn't look like you've gamed the system if you just have 92 all 5-star ratings. People somewhat become skeptical of this, and that was a study done out of Cornell on actually on Amazon reviews. But I think that there is something to that. So sometimes a little slightly off review isn't always a bad thing. And Jeff, you may be able to describe a little bit more about that.
Yeah, I'll follow up with that. So my guiding theme is that the solution to pollution is dilution, an old surgical dictum. So having a buffer of mostly positive reviews means that when the inevitable negative review comes in, it's not really a problem. And as Mike described in the study, having an occasional negative review is actually a good thing, not a bad thing. So when you get that negative review, think about sending that patient a thank you note for actually making every other review look more credible and more authentic. But I go back to Bob's original point, which is if the patient has a problem and you believe that there's a possible way to learn more about the problem and solve it, just pick up the phone and call them. You'll be pleasantly surprised that most of these problems can actually be solved. And to the extent you have solved the patient's problem, why not ask them, if they would be kind enough to either update or remove their review, and use these magic words. It's a request, not a demand. You'll respect whatever they do. So put them in the driver's seat. But most patients, not all patients, will actually react very positively to that. Some will remove it. Some will change a 1-star to a 5-star, and then comment that you picked up the phone, called them, and you listened to them and solved their problem. So communication is a good way to get a lot of this resolved. Sometimes you can go to the website itself, and if it's a violation of the terms of use, maybe get them to take an action. They often don't jump up and down about wanting to do it, but if it is a flagrant violation of the terms of use, it is possible on occasion to get it taken down. And then finally, to the extent that you do choose to respond, I would make sure you do it in a HIPAA compliant way, and then number 2, one and done. You don't really want to get into a debate. In this particular vignette, the surgeon was using the pictures to show that the patient's complaints or allegations were just not true. And if you just look at her nude pictures online, you would see that the doctor's right and the patient's wrong. So she was using it in a debate. I would argue if you're going to respond, needs to be HIPAA compliant, and then one and done. And you can say that. You can say this will be my first and only response to this particular review. But remember, your audience is mostly the public at large.
Yeah, the prospect. So agreed. I think that the advice we hear there, to summarize for the audience, is that it's permissible, but the context needs to be HIPAA compliant when a response does go out. We actually advise responding one time to both the positive and the negative reviews. And if it's negative, simply acknowledging that you'd like that person to contact you so that offline you can work together to make things better. So I'm going to leave everybody's contact information up here for a second for those that may have questions. We will have a copy of today's webinar available on recording, but I'm going to do a quick speed round because there are 2 questions that came in that I think are really great. Michael, I think it may have been you who said this, that once a person has given consent, is it true that they can revoke that consent in the future after something's already been posted?
Yes, I think it was Jeff that was talking about the terms of the authorization, but yes, they do have the ability. The question is how effective it is once some information is out.
And then,
yeah, so I mean, if you can control the website, so for example, let's assume it's your website. If you can control your webmaster and get it taken down, you should honor it. But let's say you published it in a magazine, you know, that you've got your arm around your patient in a magazine. You obviously can't recall every magazine. So it's anything you have control over, you need to honor. But if you don't have control over it, the patient needed to have been forewarned up front that, you know, once the toothpaste is out of the tube, you may not be able to put it back in.
Yeah, and Brandy, thank you for that question. We have a question from Helen. It'll be our last question as we wrap up today. So in the case that you have a patient who is doing a chargeback with a credit card company, assuming that it is a HIPAA-covered case and is a HIPAA-covered practice, how much can you actually reveal to the credit card company in defense of that chargeback?
Hey, I'll tackle that. The answer is everything. HIPAA specifically allows the use of PHI for the purposes of securing payment. So even if it is a HIPAA case, then you're completely permitted to justify to Visa or whatever that in fact the patient received the services requested. Our members routinely get this. Fortunately, the chargebacks are not routine, but when they get them, they routinely provide the medical information to show that they in fact got their Restylane injections or whatever, and they routinely are successful in defeating chargebacks. The only time I've seen chargebacks chargebacks win is when the doctor has performed services and didn't happen to get a signature on the charge. I saw that once where the patient's on the table being prepped, and the nurse realized that they didn't have full payment, and so she said, "Call my boyfriend," and he gave a card over the phone. They went ahead, they did the surgery. Suddenly, you know, a month later, there's a chargeback, and it turns out that the patient and her boyfriend broke up, and now the boyfriend is claiming, you know, hey, I don't know what, I didn't authorize this, and there's no signature, so that had to go to small claims court. Still effective, but otherwise, no, there's no problem in providing medical information to prove that in fact services were rendered.
Yeah, let me first agree and then qualify, and I'm sensitive to the time, but this will be really fast. So I agree entirely that HIPAA does allow you to share information to address a financial issue. You do not need the patient's signed authorization to accomplish that. You can just do it. But you really only need to send the amount of information to resolve the claim. And so the person on the other end at Visa isn't really interested in the details of the medical record. They're just looking to see that whatever the procedure was paid for was actually performed, and it wasn't done in such a grossly negligent way that it was as if the patient had nothing done, and that there's a signed receipt. I mean, if you send nothing more than those two things, they're pretty much checking the box on that. But if you start sending the medical record saying the patient's HIV positive and has bipolar disorder, then you're starting to move into, you know, dangerous gray zone territory.
Agree completely.
Well, gentlemen, Helen sends her thanks for that answer, and I send my thanks again to all of you for participating in today's panel. On behalf of myself and everybody who listens now and for all times to the recording, Bob Aicher, Mike Sacopulos, and Jeff Segal, I want to thank you guys for your time.
Thank you very much.
Thank you. Thank you.
And look forward to, obviously, I think we went long, so clearly there's a lot of interest here. Hopefully we'll have a chance to do this again soon. And to everybody who's on the call today and listening in on the recording, we'll wish you all the best. Thank you again for participating today, and we'll look forward to seeing you again on another webinar soon.
Thanks. Bye-bye.